Good morning or afternoon, everyone, depending on what part of the country you're in. So we want to welcome you and thank you for attending today's webinar. Peak Trust Company is honored to partner with Steve Oceans with the law offices of Oceans and Associates located in Las Vegas, Nevada, where as of today, our casinos are open. So looks like we're moving in the right direction. So before I tell you a little bit more about our esteemed presenter and Peak Trust, please bear with me as I'm going to go through a little bit of housekeeping. So this session is going to be recorded and a copy of the slide deck will be provided to you afterwards via email. And also we will be doing a question and answer at the end of the presentation. And during this presentation, everyone on will be muted. So about our presenter, Steve Oceans was inducted into the National Estate Planning Council Estate Planning Hall of Fame in 2011. He was named one of the 24 elite estate planning attorneys and one of the top estate planning attorneys of 2018 by the Wealth Advisor. He is listed in the Best Lawyers in America, which also named him Las Vegas Trust and Estates Tax Law Lawyer of the Year in 2012, 2015, 2016, and 2018. His contact information will be listed on the last slide deck, and it's also right in front of you right now. Or you can just go to oceans.com. Again, that's oceans.com. And I just have to throw in one little tidbit of Steve's latest and greatest, and possibly greatest accomplishment. He and his beautiful wife, Elena, are recently the proud parents of a sweet baby girl, Tiffany. So congrats to Steve and his family. So lastly, a little bit about us. My name is Deb Erdman with Peak Trust Company, formerly Alaska Trust Company. We're a full-service administrative trust company, and we welcome the opportunity to partner with you and your clients as you work to help them achieve their estate planning goals. Here at Peak Trust Company, we are doing our part to be safe and help reduce the spread of COVID-19. These are definitely uncertain times, and the Peak team continues to remain available and ready to provide our world-class service to you and your clients. Please feel free to reach out to myself or any member of our team, and I also invite you to browse our website at peaktrust.com. Again, that's peaktrust.com. So thank you all for your patience. And with that, I'm going to turn it back over to you, Steve.
Thank you very much, Deb. It's a pleasure to be here today, and I want to thank Peak Trust Company for inviting me to speak on this webinar. And thank you to every one of you who has taken time out of your busy schedules to attend today's session. I know that you have tons of clients, and we all appreciate that you found it valuable enough to listen to today's session. So this is a very fun topic. It's a very timely topic, and I could even tell you that this is always going to be a timely topic, and that is using out-of-state trusts to enhance your practice. This is important whether you're an attorney, you're a CPA, you're a financial planner, a trust officer, a life insurance agent. This is something that, if you're not already doing it, could really enhance your practice and enhance what you can offer your clients. So let's start with the first slide, and we're going to talk about the choice of jurisdiction. And some of you might have forgotten what I have here on the screen, which is football, because we haven't had football for some time, although it's coming back soon. But what we're going to talk about here is how we put together the planning to use and incorporate the laws of a better jurisdiction when we're designing our trusts. Many planners fail to take advantage of jurisdictional opportunities that I believe you should be taking advantage of, and I think there are two main reasons for that. The estate planners assume that it must be too complicated or too expensive, or maybe both. I assure you it's not too complicated to add a trust company such as Peak Trust Company as a co-trustee or a sole trustee over a trust in order to get jurisdiction in one of the main states such as Nevada or Alaska, where Peak Trust Company has its offices. And it's not overly expensive. Certainly, the trust company is entitled to be paid reasonable fees, but it's a small fee in relation to what we are going to be able to provide for our clients. And every time I talk about a different opportunity during today's session, I want you to think about how valuable that would be for your clients. And I'm not going to quote any trust company fees or anything like that here today, but I assure you that everything that we're going to talk about here, the client is going to get a lot more value than the money it costs to do it. So I believe that almost none of our estate planners in the industry are using out-of-state jurisdictions for trusts. It is such a tiny percentage that I know that if we can influence and sway your ways of thinking, I think we can make a huge difference in your practices. So let's go to the next slide, and we're going to see that there are significant opportunities that I'm going to talk about in today's session. Certainly in an hour, I can't talk about everything that's out there, but what I've focused on here today are a lot of the main opportunities. First, I'm going to be talking about Dynasty Trusts. Then I'll be talking about domestic asset protection trusts, and I will follow that with hybrid domestic asset protection trusts, which is the granddaddy of all asset protection vehicles, and it's a twist off of the regular domestic asset protection trust that is much more protective. Then we're going to talk about trust decanting, which is a way to make changes when we otherwise had an irrevocable trust. And finally, I'm going to end with using out-of-state trusts to save state income tax. This is a huge hot topic right now. So hopefully you'll all get something from today's session. So let's start by talking about Dynasty Trusts. The Dynasty Trust should be the centerpiece of nearly every estate plan. This should be where you're starting whether you're drafting a revocable trust where you would add Dynasty Trust provisions. Am I okay? Okay, whether you would
yes, go ahead, Steve.
Okay, whether you would use the Dynasty Trust provisions in the revocable trust, or you would also use irrevocable gift trust with Dynasty Trust provisions, this should be the centerpiece of nearly every estate plan. So let's go through what a Dynasty Trust is. A Dynasty Trust is an irrevocable trust that is not subject to estate taxes for as long as applicable state law allows. So it's a long-term trust that avoids state taxes for as long as the trust continues. And if drafted properly, it can also be protected from creditors of the beneficiaries and also divorcing spouses of the beneficiaries. When I say drafting it properly, we're generally going to either draft the trust as a fully discretionary trust or as a support trust. The better way to draft it, and the way we draft the trust more than 99% of the time, is as a fully discretionary trust, which is where generally the primary beneficiary is the investment trustee, and the best friend or the trust company located in the key jurisdiction is the distribution trustee, or we can even add a third trustee, which is the jurisdictional trustee, if we want the best friend to be the distribution trustee. That is a fully discretionary trust. That is the most protective trust from the standpoint of protecting the assets from creditors and divorcing spouses of the beneficiaries. Alternatively, and not as good, is to use a health, education, maintenance, and support type of Dynasty Trust, where certain jurisdictions will open those trust assets to divorcing spouses and other certain types of exception creditors. So you can do it either way, but generally the fully discretionary trust is the way to go. The key states for Dynasty Trusts are Nevada, South Dakota, Alaska, and Delaware, which are generally considered to be the Tier 1 states. I believe we've all just been saying that for so many years that we believe it. If you asked me, I would say that of those four, I wouldn't include Delaware there. I would tell you Nevada, South Dakota, Alaska are above Delaware, but Delaware is still one of the better states. Peak Trust Company has offices in Nevada and Alaska, so of these four states, Peak is represented in two of them. Let's go to the next, and I should say before this next slide, what you need to do to use the laws of the other state is to simply add a co-trustee located in that state, whether it's an individual or a banker trust company. So on this next slide, let's talk about what not to do. This is the exact opposite of a dynasty trust. It's called a staggered distribution trust. I need you all to make a promise to me. I want you to promise that you don't come away from today's session and tell everyone that Steve Ocean's taught you about staggered distribution trusts. It would ruin my reputation. Staggered distribution trusts are not the way to draft a trust, yet nearly every trust that is drafted in our industry is drafted this way, and nearly every might mean 95% or 90%, but a lot of trusts are drafted where there are mandatory staggered distributions made at staggered ages, such as 1/3 to my child upon reaching 25, half of the balance at age 30, and the balance at age 35. The philosophy behind a staggered distribution trust is you give your beneficiary multiple shots to screw up. If the beneficiary screws up the distribution that's made at age 25, he or she has a second opportunity at age 30 and then a final opportunity at age 35. It's kind of like the 3 strikes law. The philosophy there doesn't make sense to me at all, because what you're doing is you're forcing the assets out of a trust that was protected from creditors and often divorcing spouses as well, especially if it was a fully discretionary trust. If the statistics tell us that roughly half of marriages end in divorce, why wouldn't we take the position that nearly every one of our clients' descendants are going to have at least one divorce amongst them and draft accordingly? So rather than a staggered distribution trust, which forces the assets out of the trust and into the hands of the creditor or divorcing spouse, let's always just draft the trust to stay intact for multiple generations for as long as state law allows, and therefore protect the assets. And instead of forcing the distribution out at age X, let's instead appoint the beneficiary as the controlling trustee upon reaching age X. So the beneficiary has what we call a beneficiary controlled trust, but where nobody can take it from him or her. That is A+ level drafting. If it makes sense to do that at the first generational level, then it makes sense to do that for the grandchildren, makes sense to do that for the great-grandchildren, the great-great-grandchildren, and so on and so forth. If you use one of these key states, such as Nevada, Alaska, South Dakota, etc., you can have that trust go on for a long, long time and be protected. So let's go to this next slide. And why do we use a dynasty trust? The traditional answer to the question of why do we use a dynasty trust has been to save estate taxes. When I got out of law school in 1994, I'm starting to feel old now, this is all we heard about. Use a dynasty trust to save estate taxes, because at that time the federal estate tax exemption was only $600,000. Now that the federal estate tax exemption here in 2020, when this webinar is being recorded, is $11.58 million per person, or $23.16 million per married couple, a very small amount of our clients actually have a federal estate tax. So under that theory, estate taxes should not be our underlying most important reason for the dynasty trust. But for our ultra wealthy clients, and I'm going to define ultra wealthy as simply being over that $23.16 million barrier, then the dynasty trust becomes very important, because we want to keep the assets out of the children's and grandchildren's and great-grandchildren's estates. Let's look at the other prongs on this slide. We also want to use dynasty trust to protect assets from creditors and divorce. I've already talked about that. To me, that might be the most important reason we're using the dynasty trust. The estate taxes don't apply to a lot of the clients, or especially by the time you divide up the estate for multiple children, they tend to be under the exemption. That there is no such exemption for creditors and divorce. Like I said, roughly half of the marriages end in divorce. Let's plan accordingly and assume that there will be at least one divorce down every client's family line. And I know that that's not a true statement, but for the most part, it will be a true statement for most of the clients. And then third on this slide is to shift income to lower federal tax brackets. So if we force the distributions out to the beneficiary at ages 25, 30, and 35, for example, and the beneficiary is in the highest federal tax bracket, and then we don't have the ability to shift income to the grandchildren who might be in lower tax brackets. So this is often another feature of keeping the assets in a continuing trust. Fourth on this slide is to save state income taxes. To me, this is a huge amount of our planning right now, especially because the state and local tax is only deductible up to $10,000 per year against federal taxes, the so-called SALT deduction limits, and therefore our clients generally are there simply because of their real property taxes. So all of their state income taxes are no longer deductible against federal taxes. If we can keep the assets in a dynasty trust and we can draft around the state long-arm statutes, which I'm going to be talking about towards the end of this session, we can avoid the state income taxes very often on income that the beneficiary doesn't need or want. If the beneficiary is already in the highest federal bracket and also has a state income tax, there's no reason to make a distribution to someone who doesn't need or want the income. So let's keep the assets in the trust and the income in the trust so we can avoid state income taxes that are no longer deductible. Fifth here is to be able to give beneficiaries general powers of appointment over low basis assets. This is 21st level planning. If we were to force the assets out to the beneficiaries at ages 25, 30, and 35, when that beneficiary dies, assets that have a fair market value in excess of the basis will get a step up in basis, and assets that have a fair market value that is lower than the basis will get a step down in basis. We want a step up, we don't want a step down. Therefore, we don't want to distribute all the assets and force them out to the beneficiary. If we keep them in a trust, we can selectively give the beneficiary by formula a general power of appointment, which is a power to appoint to themselves or their creditors, which therefore causes estate inclusion at their death with a formula that won't cause any federal or state estate tax, but gives them a step up in income tax basis on their rental properties that they depreciated down to close to zero, on their brokerage portfolio that has grown in value, etc. But their assets that have done the opposite, where we don't want to step down in basis, we keep in the trust and don't give them this power, so we don't cause estate inclusion and we don't get a step down in basis. This is awesome planning that we can do with the Dynasty Trust. Let's go to the next slide and we'll talk about domestic asset protection trusts. So I'm giving you roughly 10 minutes on each topic here, just so you have enough to see that there's opportunities here that you might be missing with your practice. So going into the domestic asset protection trust. A domestic asset protection trust is a U.S.-based irrevocable trust in which the trust grantor or settler sets it up for the benefit of him or herself and other beneficiaries, generally for the benefit of the grantor, grantor's spouse, and grantor's descendants. And under the laws of 19 different jurisdictions, those assets should be protected if the grantor were to be sued. We don't know for a fact if that will be the case for people that are not residents of the Domestic Asset Protection Trust jurisdiction, and I'll be going through that, I believe, on the next slide or the next few slides. But for someone who's a resident of a DAP jurisdiction, we know it works. So Nevada is considered the leading domestic asset protection trust jurisdiction. Certainly Alaska is up there in that analysis. It's going to be those Nevada, South Dakota, Alaska, Delaware types of states. Nevada has a 2-year statute of limitations period, so put the assets into the trust, and with respect to non-pre-existing creditors, meaning future creditors, the Nevada law says there's a 2-year statute of limitations period. Most people believe that that means that you get the protection 2 years after the assets are placed in the trust. I wrote an article roughly 4 years ago, I believe, that argued that nobody actually reads the Nevada statute. If you actually read the statute, it doesn't say it takes 2 years to get protection. It says that no creditor can sue after 2 years. That's different than saying the protections after 2 years. It says that you have protection as long as the transfer to the trust wasn't wrongful or fraudulent within the fraudulent conveyance statute. So I believe that as long as there's no creditor issue, no lawsuit, no threatened lawsuit, no action that will reasonably turn into a lawsuit, the protection should be there on day one. One of these days, someone will hire me to be the expert witness, and I will go through that in court, and we will have a court case that says that I'm right. So Nevada has a very low 2-year statute of limitations period. With respect to a pre-existing creditor, one who currently has a claim, it doesn't mean has filed a lawsuit or threatened a lawsuit. It means has a claim. Someone who the client has hit with a car last week, even if they haven't filed a suit, is a pre-existing creditor. The statute of limitations period is told to the longer of 2 years from the date of transfer to the trust, or 6 months from the date the creditor discovered or reasonably should have discovered the transfer to the trust. That is to protect someone who didn't know about the transfer to the trust. Under the laws in Nevada and a handful of other domestic asset protection trust jurisdictions, you can get that 6-month tolling clock started by making the transfer a matter of public record. So what we do is we publish in a small newspaper an announcement that a transfer has been made, and I think we publish 3 different times. We don't publish it in the newspaper that everyone reads, but we publish it in a newspaper, which hopefully is enough to get that statute running. If you publish on day one, you get that 6-month tolling period to end 6 months into the 2-year statute of limitations period, therefore turning even a pre-existing creditor situation into a 2-year statute. Even though I just made this sound like you can make fraudulent transfers after the fact, you cannot. So if the client is aware of they've been sued, or they're aware that they've been threatened with a suit, or they are aware that they caused a probable suit, or that they've ripped someone off, or they owe someone money, a transfer to one of these trusts in any of these jurisdictions is probably not going to work, because they will be deemed to have made a fraudulent transfer or fraudulent conveyance. When you make a transfer with the intent to hinder, defraud, or delay a creditor, you've made a fraudulent conveyance, and it's probably going to get unwound. So you as the advisors need to take what I'm saying to mean that you need to be proactive and proactively go to your clients and prospective clients and say to them, should we talk about protecting some assets and taking some chips off the table now while the coast is clear? Human nature is such that clients will often wait until they've been sued, threatened with a lawsuit, or they've done something that they think will turn into a lawsuit before they start asking their advisors about how to protect their assets. That is not asset protection planning. Those are fraudulent conveyances. So there's a chicken and egg problem here. Human nature is such that clients don't want to pay to get this done until they know they have a problem. But once there's a problem, it's too late to get it done. You as the advisors need to hold their hand and tell them, just like you buy your homeowner's insurance before your house is burned down, you buy your automobile insurance before the car accident, you buy your life insurance before you're in hospice or before you died, you buy your health insurance before the doctor tells you you have a disease. Same thing here. You have to buy your asset protection insurance, let's call it, before the problem has occurred. Let's go to the next slide. Does a domestic asset protection trust work? And I've hinted about this on the last slide. We know for a fact that a domestic asset protection trust definitely works for a resident of the domestic asset protection trust jurisdiction. So if a resident of Nevada sets one of these up, we know it works. If a resident of Alaska sets one of these up, we know it works. Does it work for a resident of a non-domestic asset protection trust jurisdiction who sets it up under the laws of the state that has these statutes? We're not 100% sure. The history is on the side of the debtors here. After 23 years since the first state enacted domestic asset protection trust laws, which was Alaska in 1997, there is really only one case that says does it work or does it not work for a non-resident? That was the Huber case, Huber, out of the state of Washington. Donald Huber made a transfer into a domestic asset protection trust well after he should have. He ended up going through bankruptcy and he blatantly made a fraudulent transfer. So his situation clearly wasn't going to work because he waited too long. The judge in the Huber case, which was in bankruptcy court, ruled in dicta. Dicta means where the judge wants to say something even though it's not relevant to the actual holding of the case. He ruled in dicta that in a choice of law analysis, you apply the law where the client resides if there's a strong public policy in that state to not approve these trusts. And in the state of Washington, which is not one of the 19 DAPT jurisdictions, there's a strong public policy that you can't set up an asset protection trust and be a beneficiary. So the judge ruled that it wouldn't have worked. I will tell you the judge was completely wrong. He applied the wrong restatement of the Book of Conflicts of Laws. He should have applied a different statute in there, which doesn't look at whether it's a trust that works. He should have looked at the statute that says, is it a protected spendthrift trust? Had he done so and looked at and applied the right rule, that particular rule of law doesn't look at the public policy of the state where the resident lives. It looks at the selected law in the trust agreement, and in that case, it would have been a protected trust. So I believe if the judge were to revisit this and apply the right rule of law, the judge would have ruled the other way. Now, the great news is after 23 years, there's only that one case that suggests that it wouldn't work for a non-resident. The reason that I think there's only one case is domestic asset protection trusts are so scary, and if you apply what I like to call the fear factor in the asset protection world to this situation, when a creditor sees a scary structure, the creditor will usually settle, because what happens is if we make the structure really scary, and especially if you set up a regular DAPT along with a charging order protected LLC or limited partnership, charging order meaning a lien that would apply to the LLC or LP, if you make it scary enough, the creditor usually will give up and settle for pennies on the dollar. That's why we don't see a lot of court cases here. There must be a ton of settlements. So the domestic asset protection trusts have been working very nicely. If you understand that in the definition of whether they work, we also include all the out-of-court settlements that we never see. But we can actually do better. Let's talk about the better version of this. And I told you earlier, this is the granddaddy of all asset protection structures. That is called a hybrid domestic asset protection trust. The hybrid domestic asset protection trust is really not a DAPT. It's a marketing term. It's not a domestic asset protection trust. It's a third-party irrevocable trust. So I set the trust up for the benefit of my spouse and descendants. And Deb told you that I had this nice addition to my family, little baby Tiffany, who was born 10 weeks and a day ago. So I actually now have a descendant when I'm saying this. I didn't have one before. So if I didn't live in Nevada, I would set the trust up in a state like Nevada or Alaska, and I would set the trust up for the benefit of my spouse and descendants. I would not make myself a beneficiary. That's a hybrid DAPT, but the hybrid DAPT has this hybrid provision that allows me as the grantor to appoint a trust protector at a later date, and I'm going to appoint my best friend who's probably going to do whatever I want and sign whatever I ask, who has the power to add additional beneficiaries from the group consisting of the grantor's grandparents, descendants, including the grantor, which is including me. So if, heaven forbid, my wife, Elena, were to predecease me and I run out of money, or she divorces me, then if I really need to be a beneficiary, I have the ability to be added in through a back door by appointing my best friend as trust protector who has the power to add me as a beneficiary, and I can get a distribution. Now, I will tell you folks, this is more psychological than anything, because we have done more than 2,000 hybrid domestic asset protection trusts when you include the incomplete gift version, which is pure asset protection, and also completed gifts such as irrevocable life insurance trusts, exemption trusts, annual exclusion gift trusts, where we build this hybrid provision in. In more than 2,000 of these, we've only added in one grantor, and that was because she wasn't listening to me when I told her we were going to run money through her husband. She just missed that somehow in the pitch, and she just said, there's no way I'm comfortable, and we added her in. Other than that, this is more psychological than anything, and I'm going to show you why we have the ability to easily access cash flow without the grantor being a beneficiary. So let's assume the grantor sets up the hybrid DAPT for the benefit of grantor's spouse and descendants. What are the different ways we can access cash flow? And everything that you see on this slide is not every way that we can access it. I have other ways, but the most obvious is a distribution to the grantor spouse who shares it with the grantor. For our clients who are unmarried, or we can still set this up, they can always get married, and if it's an incomplete gift version of this, which means that we would draft it where the grantor retains a lifetime and testamentary power to appoint income or principal to anyone in the world but the grantor's estate, the grantor's creditors, or the creditors of the grantor's estate. Even if there's no spouse, grantor can exercise this power of appointment and appoint income or principal to their boyfriend, their girlfriend, their brother, their sister, their mother, their father, their child, their next door neighbor, their best friend, or their future spouse, even if we didn't include spouse as a beneficiary. There's all these different outlets to someone who then can either share it with the grantor or not share it with the grantor. Obviously, a distribution to the spouse is the most comfortable option here, assuming they get along. And if they didn't get along, they shouldn't be married. Now, when we're putting this structure together, we will transfer a larger amount of the net worth into a trust where we know there's a happy marriage and a spouse as an outlet. If the client is not married or is not comfortable running through any income through the spouse except in an emergency, which means the client's been sued and lost everything else, and now we don't have a choice or much of a choice, we will put a smaller amount of the net worth in, and we will put other assets that we don't put into this trust in a charging order protected LLC or LP, which means the creditor gets a charging order or lien against the LLC membership interest or partnership interest in the limited partnership. So we protected what we didn't put in, but at the same time, now we need to turn the spigot on in the hybrid DAPT and either run money through the spouse, run money through son, daughter, brother, sister, mother, father, boyfriend, girlfriend, next door neighbor, best friend, who then can either share it with the grantor or not share it with the grantor, and we can clearly find at least one of them to share. Secondly, on this slide, we can always give a beneficiary a broad, non-general power to appoint income or principal to anyone in the world but himself, his estate, his creditors, or the creditors of his estate. They can then exercise that power to appoint back to the grantor. I don't love that. I threw it onto the slide, but I prefer to make a distribution to that beneficiary and then have that beneficiary or other recipient just simply share with the grantor. Third, we can have the client sell assets to the hybrid DAPT in exchange for a promissory note. So for the client who's unmarried, who wants to set one of these up, doesn't want to be the beneficiary, so we have a higher probability of success. Let's assume we take a $2 millionaire who doesn't own their home and they have a $2 million investment portfolio. That's 100% of their assets. What we can do is put $1 million into the trust and have them sell their other $1 million to the trust, which is a tax-free sale, in exchange for a long-term promissory note that pays them back $1 million plus interest. So they live off of the $1 million plus interest. And therefore, we didn't make them a beneficiary, yet they're a beneficiary of the promissory note receivable. That is a slick way of creating a hybrid DAPT for someone who wasn't married, which is an example of why, even if you're thinking, gee, my client doesn't have a spouse, this won't work. If you put us up to bat on this, we probably have a structure that works for that fact pattern. We almost always do. So in this case, the client can get the cash flow via the note receivable, even though the client didn't have a spouse and isn't a beneficiary of the trust. That's nice and creative, and it gets us to point Z from point A, even though we didn't have a spouse. that's a great structure. And then finally here we can have the trust loan money to the grantor for a promissory note. Don't do too much of that, but a little bit of that is fine. Let's go to the next slide. Down and dirty, splitting the trust. This is what I call the clean trust versus dirty trust concept. Let's assume that our client has thrown a couple $1 million into this hybrid DAPT, and meanwhile, client went through some horrible divorces. Fortunately, the hybrid DAPT was protected from divorces, and the client lost other assets in a divorce, was sued multiple times, lost other assets, and made horrible investments. And fortunately, there's a couple of $1 million in this trust, and our client really could use some cash, and our client's no longer married, and our client could just use some money out of the trust, but we don't want to subject the entire $2 million trust to creditors. What we can do is simply divide off the trust into a Trust A and a Trust B. Trust A is still the hybrid DAPT, which you all know is nothing more than a marketing name for a third-party trust, which we know is protected from creditors as long as it was set up in advance of any sort of a creditor or potential creditor situation. So we maintain, let's say, $1.5 million or $1 million in that Trust A, and we split off $500,000 or $1 million into Trust B, and the grantor is added as a beneficiary over this Trust B, which I'm going to call a dirty trust, even though it's really not dirty. It's just a little bit dirtier than it was before, because if the creditor is able to successfully be the very first plaintiff to get a judgment against a debtor, and then be able to bust through their domestic asset protection trust in a scenario where it's not a bankruptcy and not a fraudulent transfer, making them the first ever in 23 years of these, by the way. And the client then appeals to Nevada or Alaska, wherever you've set this up, and the Nevada judge or Alaska judge rolls over and lets it happen, which I seriously doubt. This would be the first time that has ever happened, and therefore at least they've only lost a few $100,000 that's left in the dirty trust by the time it gets through the trial. Meanwhile, the grantor is living out of that trust, and we've protected the clean trust. Let's move on to decanting. So this looks like one of your clients who has come to you and says, I can't change my trust. How could I have anticipated my child having drug and divorce problems? So an irrevocable trust is not necessarily irrevocable anymore, because there are 29 jurisdictions that have decanting statutes that will allow us to decant a trust to essentially make changes to the trust. The traditional reason to make changes is because the client was unhappy with a provision in the trust. But I will tell you that more often, and much more often, let's say 90% more often, it's because we as advisors review their irrevocable trusts, and we find that we can enhance the trust, whether it's enhancing asset protection, divorce protection, state income tax savings, or some other enhancement. We have a reason to want to change a trust. Decanting a bottle of wine, which you all know, is where we have the person pour the liquid into the decanter, leaving the unwanted part of the liquid in the original bottle, and putting all the good liquid into the new bottle. That is decanting wine. Just as you can decant wine by pouring it from its original bottle into the new bottle, leaving the unwanted portion in the original bottle, the trustee can pour the assets from one irrevocable trust into a new irrevocable trust for the benefit of one or more of the same beneficiaries of the old irrevocable trust. You can't even add one beneficiary or it's an invalid decanting, and therefore change the terms to enhance the trust for the beneficiaries. Like I said, there are 29 states with decanting statutes. 7 of those states do not require notice to beneficiaries. I call this a private decanting. It's not about doing things behind the backs of the beneficiaries. It's about the fact that our clients want privacy. You see the 7 states that don't require a copy of the current trust and a copy of the proposed decanted trust and a copy of the decanting agreement, which is the agreement that says the trustee will make distributions to this new trust. We don't want to have to send that to all the beneficiaries. So even if your state law where the trust is situs and is under says that you have a decanting ability and you don't want to have to send copies of everything to the beneficiaries, consider using one of these 7 states. Most notably, the top 2 are South Dakota and Nevada. Again, Peak Trust Company has an office in Nevada, so use Nevada here. And you can have a private decanting and make whatever changes you want within the bounds of what the law allows. Let's go through some common reasons to decant. Probably 3/4 of the time when we're decanting, it's about extending the term of the trust. So this takes us back to that staggered distribution trust. As long as those staggered ages have not yet vested, we can have the trustee move the trust to Nevada or Alaska, as long as there's a change of situs provision in the trust, or they use either a decanting statute located in the state where the trust is situs to move the trust situs to Nevada or Alaska, or they use what's called a non-judicial settlement agreement, if there's a statute in that state that allows it, to move the situs to Nevada or Alaska. Then we decant the trust under the laws of Nevada or Alaska, and we extend the term of the trust beyond the term of the original trust. We can't enhance the perpetuities term because that would trigger what's called the Delaware tax trap and cause a taxable event. But we can take a single generation trust and make it into a 3 or 4 generation trust by extending the term so that the beneficiaries get divorce protection and protection from other creditors and certain federal income tax opportunities, state income tax opportunities, basis bump opportunities. A lot of the things that I talked about on the Dynasty Trust slide, we can create those opportunities by extending the term of the trust. Changing a support trust into a discretionary trust. I believe there are 8 of the 29 decanting jurisdictions, that includes Nevada for sure, that allows you to decant, to change a health, education, maintenance, and support trust into a discretionary trust. Why would we want to do that? For 2 reasons. Number one is enhanced creditor and divorce protection, because a lot of the states have an exception creditor statute, either by judicial creation in court or by statute, that will allow a divorcing spouse, for example, to pierce through a health, education, maintenance, and support type of trust. That's why to never use health, education, maintenance, and support. Just because the forms say to use it doesn't mean that you need to use it. You're better off with a fully discretionary trust with a third party, either best friend or trust company as a distribution trustee, and primary beneficiary generally as the investment trustee, but not always. That is a fully protected trust. So we will often take a health, education, maintenance, support trust, especially one that is situs in a state that has divorce as an exception creditor. We will move it to Nevada, let's say, and then decant it into a fully discretionary trust. On this next slide, saving state income tax on undistributed income. Sometimes it's as easy as just having a trustee who lives in a state that is causing the state income tax to simply resign. But other times we have to maneuver the trust a bit to save the state income tax. So what we'll do is we'll decant the trust by having the trustee distribute the assets into a new trust for the benefit of the same beneficiaries of the old trust, but where we fix it by avoiding a trustee in a state that's causing a tax, or administration in a state that's causing a tax, or whatever is causing that tax. We will fix it by decanting the trust. The next slide, indirectly adding a beneficiary. I told you on a prior slide that when you decant a trust, you can't even add one additional beneficiary. So if the trust is for the benefit of my spouse and 4 of my 5 children, I can't have the trustee decant a trust to make it for my spouse and my 5 children. But what I can do is I can very cleverly indirectly add a beneficiary by decanting to give a current beneficiary a very broad power of appointment that includes the appointees that were not beneficiaries of the first trust, and ask that beneficiary to exercise that power of appointment, whether during life or at death, to give that person, maybe it's my child that I cut out years ago, that I wish I would have left in there now, because I'm now on speaking terms with the child, to give that beneficiary or beneficiaries these powers of appointment to appoint income or principal to someone who wasn't even a beneficiary in the first place. Nice and clever. That's how we can get from point A to point Z. On the next slide, correcting drafting errors or ambiguous terms. Raise your hand if you're an attorney and you've ever misdrafted a trust. I'm raising my hand right now. By the way, I haven't drafted a trust in about 15 years. The attorneys at my firm don't let me draft. Let's put it that way. My job here is to get clients. But I'm half joking. I still have my skill set, but it's a little weak and slow. But I'm human. I've made errors. We've all made errors. Here's a great way to decant the trust to fix the error, so we don't have to petition the court for a reformation. Let's look at the next slide. So the final topic I'm going to talk about is saving state income taxes. So I've taken you through a lot of topics. Let's talk about state income tax planning. This is such a huge topic right now, given that the SALT deductions or state and local tax deduction is limited to $10,000 per year. Especially for our wealthy clients, they hit that simply with their real estate taxes. So let's talk about how we can use out-of-state trusts to save state income tax. So you see on this slide, and this is clip art. I know it looks like a lot of your clients who are angry when you tell them that they have a state income tax on accumulated trust income, and they look at you with this same look. Let's see if we can turn this frown into a smile. So we can use certain non-grantor trusts where we draft around the state long-arm statutes to avoid any state income tax. First of all, do you have a client who has a trust and the trust is paying state income taxes now? Take a good look at that trust and see why it's paying state income taxes. See if you can move that trust to Nevada or Alaska with no state income tax, and see what needs to be modified to avoid the state income tax. It's not as simple as just moving the trust. You have to take a look at the state statutes that are causing the tax. Different states will tax a trust based on different factors. Some will tax solely because of the residency of the settlor or testator if it was a trust set up through a will. Some states will tax based on the residency of a trustee. Some will tax based on the residency of a beneficiary, although that was recently ruled unconstitutional, at least if it's a fully discretionary trust, but not a health, education, maintenance, and support trust. So that's why you might want to decant and change that. Some will tax based on where the administration is taking place. Some will tax where the primary administration takes place. Some will tax on multiple factors here. You have to take a look at that. If you go to my website, you'll see my various charts, and there's a 2-page chart that shows you the rules in all 50 states that I update every year. If you want to take a look at that at any time, and it has links to all the state statutes. But you have to take a look at that statute, or at least look at my very short 1 to 3 line summary, and see what it takes to work around that, and then decant the trust to fix that. If you're setting up a new trust for a client, we're setting up a lot of gift trusts right now where we set them up as non-grantor trusts, and we use a state like Nevada or Alaska to avoid the state income tax on new trusts. So you have to take a look at the trusts. What do we do about assets that are currently in our client's name or revocable trust name? There must be a way to save state income taxes on personal assets. You see my friend here on the clip art with the nerdiest guy I could find. Anyone who has tape holding their glasses together is nerdy, but nerds are usually smarter than the rest of us. They make up for their nerdiness by being smart. He has a way to save state income tax. There are two main opportunities here. One is a resident of a state with a high state income tax who has low basis assets or asset that they want to that they can contribute to what's called a Nevada incomplete gift non-grantor trust. The N stands for Nevada. If it was Alaska, then substitute an A in there. There are a handful of trust jurisdictions where this works. The trustee can sell the low basis asset and avoid state income tax on the sale. The second opportunity would be a resident of a state with a high state income tax who contributes an investment portfolio or other assets such as out-of-state rental properties or a promissory note receivable or an investment in an out-of-state business that's not throwing off income that's sourced to the client's home state. Investment portfolio is the best example here. Contribute that to the Ning Trust. The trustee can continue to invest a portfolio and avoid state income tax. That's your other main opportunity. So I believe this is my final slide. This is just a description of a Ning Trust. For those of you who want to know what it is, it's a non-grantor domestic asset protection trust, so it must be set up in one of the DAPT jurisdictions. It's a non-grantor trust for income tax purposes, so we can avoid state income taxes. We use a distribution committee or power of appointment committee made up of adverse parties to make distribution decisions. That negates the grantor trust rules, which means that the trust is its own taxpayer in the zero state income tax jurisdiction, but yet transfers to the trust are incomplete for gift tax purposes by having the grantor retain a broad testamentary non-general power of appointment and a lifetime retained non-general power of appointment over corpus only in a non-fiduciary capacity for health, education, maintenance, and support. If you've never set up one of these Ning trusts, I went through this slide so much faster than you needed to hear. Disregard all these concepts here and just trust me that there's a way that we can avoid state income tax for a lot of these clients who live in a state with a high state income tax. I just wanted you to know that it's out there. I know I went through a lot in 51 or 52 minutes, and I'm going to now turn this back over to Deb, and Deb is going to go through the questions, and I'll hopefully be able to answer all of your questions.
Wow, thank you, Steve. Really appreciate that. That was great information. A lot of it all of it very timely. Much appreciated. So yes, we do have some questions teed up for you, Steve. So with that, I will start. Well, first, one is a comment from James Rice. He says, congrats to you and Elena. So there you go.
Thank you, James. That was the best question of the 5. I'll tell you that already.
I thought you'd like that. Okay, so let's start with a first question from Thomas Hackett. What do you think about making beneficiary co-trustee at a certain age when then the beneficiary sole trustee at a later age?
Okay, thank you very much for this great question. I don't love that because while the beneficiary is the co-trustee, the trust can be designed to be a fully discretionary trust as long as the other trustee, that independent trustee, is the one that makes all the distribution decisions. The key from my perspective is if you design the trust with health, education, maintenance, and support, which is what you would have to do if that child becomes the sole trustee upon reaching that later age. If that trust is situs and under the law in a state that has divorcing spouses as an exception creditor, either by judicial creation or by statute, I don't think that's a well-drafted trust, even though me saying that is insulting more than 90% of my industry, which is why I don't have a lot of friends. I wouldn't draft it that way. And the other thing you need to know is I didn't go into a lot of the details in the state income tax, but if any of the beneficiaries in a trust that would have to be drafted with health, education, maintenance, and support, like the one you described, live in either California, North Carolina, or Georgia, or Tennessee, which has its state income tax at 1% this year and going away next year. If you have even one beneficiary of a HEMS trust in one of those states, you're going to cause a state income tax. And there's a lot of people that live in California. So I would assume that one of the beneficiaries could move to California, North Carolina, or Georgia, and not draft it that way from a state income tax standpoint as well. And I apologize to the 90% of my industry that I insulted. Bear with me. I'm speaking what I believe to be the truth. Thank you for the question. Deb, let's go to the next one.
Okay, next one. We've got 9 questions, so we're going to get to as many as we can. We're going to try to keep it. We may go a little over the 10 o'clock or over the hour, so just bear with us as we're going to try to get through as many as we can. Next question is from Mr. Morris. Is there a 2-year limitation on taking principal out of the DAPT, the Domestic Asset Protection Trust?
Okay, thank you for that question. No, you can actually unwind the DAPT the day you set it up. So let's say I drafted your DAPT, and later that night you see me on America's Most Wanted, and you say, "Oh my gosh, I don't know what I got myself into." You can unwind that DAPT that same day, and by having the distribution trustee sign a piece of paper directing the trustee that's on the accounts, which is generally the investment trustee, to distribute 100% of the assets and liabilities, or principal, as you call it, or corpus, back out to the grantor. You're not locking them in there for 2 years unless you somehow drafted it that way, which you wouldn't have. So no, you can get everything out of there immediately. Now, if you did the hybrid, it would be a little different, but great question. You can get it immediately. You're not losing your assets. You're not throwing them into the river somewhere and finding the key in 2 years. So thank you. Great question. Deb, let's go to the next question.
Next question from James White. If a resident in a DAPT state, can they set up in a better DAPT Tier 1 jurisdiction?
Thank you. That's a great question. They absolutely can. For example, I have a lot of clients, for whatever reason, in Hawaii. I have a lot of referral sources there. Even though Hawaii has a DAPT statute, which I have ranked as one of the worst, but worst is better than none. A lot of the Hawaii residents, I will set them up under Nevada law, simply because the Nevada statute is so much better. So yes, you can set it up under the laws of the other DAPT state. Now, the cost to do that is that you need a co-trustee there, so you have a small but very fair annual cost there. But what you might be getting out of that, and we don't know the exact answer to this, is if the client or grantor is sued in their home state, if their home court applies Nevada or Alaska law where they set this up, then that was a brilliant move to set it up there. There is still a choice of law issue there, and I went through that a little bit in the Huber case. If the local court claims that local law should apply, and the only opinion that matters is the judge's, even whether it's right or wrong, then you set it up in the other state, possibly for nothing, but at a bare bones minimum, you made it a whole lot scarier for the creditor. And remember that I put a lot of emphasis on fear factor. If you can get into the creditor's head and you can control his or her mind, and you can almost force a settlement by making it scarier by going to Nevada or Alaska rather than using a state such as Hawaii. Sorry for picking on Hawaii here, but it's my one example. So yes, you can do that, and yes, you usually should do that. But for the client who has a smaller net worth and maybe is trying to keep a few costs down, and they're okay limiting their protection to their local law, which has a bad but still acceptable DAPT jurisdiction statute, then keep it in their local state. We go through the facts and we counsel our clients and tell them what we think they should do. Great question. Thank you.
All right, next question. Are you good with keeping going? Because questions they keep coming, Steve.
I can go 10 minutes after the hour, and then I have a hard stop.
Okay, 10 minutes. So let's kick it in. We've got about 7 more here. Okay. Next question from Mike Millard. How will a Dynasty Trust be taxed that is set up in South Dakota, so where there's no state income tax? And please highlight the federal tax.
Thank you. Great question. So if this Dynasty Trust is set up in South Dakota where there's no state income tax, if it's a grantor, we can tax an irrevocable trust either as a grantor trust to the grantor or settler who set it up using the grantor rules that you find in section 671 to 679, or we can tax it to a beneficiary under section 678, or we can set it up as a non-grantor trust by taxing the income to the trust, except to the extent it makes distributions of distributable net income to a beneficiary, where the beneficiary would pay that tax and the trust would get a deduction. So we can draft it either way, or any of those 3 ways. And then as far as who pays the tax and that sort of thing, I think you're asking about some federal opportunities. If it's taxed to the grantor or to the beneficiary under the grantor trust rules, you are locked into that person's rate and that person paying it. However, once the grantor or settlor dies, it then becomes a non-grantor trust, taxed to the trust except to the extent of distributions to the beneficiaries. So the non-grantor trust is the only version there where we can sprinkle income to lower bracket beneficiaries. That's the most flexible way. So every fact pattern has its best way to go. That is the way with the most flexibility to use other brackets. Thank you. Great question. Let's go to the next one.
Next question from Eric Abramson. Eric says, Steve, if the client wants to ultimately get the money back for whatever reasons, when are you comfortable unwinding the Ning Trust post-sale? Thanks, Eric.
Okay, thanks. And Eric is one of my really close friends, by the way. So hi, Eric.
Hi.
So that's a tough question. If we set up the Ning Trust, which is to save state income tax for a huge event such as a sale of the client's $50 million business, then I like to at least wait past their home state's statute of limitations period, whether it be 3 or 4 years, for example, to make any distribution back to the grantor. I believe that we should be doing everything we can to keep the privacy of that trust. Once you have a distribution to a resident of that state, you now have some sort of a tax filing, and you might as well just jump up and down and say, hey, I'm waving my hands. Would you like to audit me? If you don't get audited, you can't lose. Now, we don't practice based on the fact that you just throw assets into a horribly drafted trust and hope we don't get audited, but we want to work with probabilities here. If you're just talking about a situation where you put their $5 million investment portfolio in, and it's still better to not have any distributions, but if we're not talking about a huge tax savings in year one, for example, where we're saving them hundreds of thousands or even millions of dollars of state tax, if we're talking about one where we're saving $20,000 a year, then you could start having a distribution in the first year, but you're better off leaving more assets out, paying some state income tax, putting less in, and not taking any distributions from a risk analysis. So thank you, Eric, and great to hear from you as always. Let's go to the next question.
From David Lane, how can you use a Nevada trust to avoid California income tax throwback rules?
Okay, thank you, David. The answer is you can't, and just so everyone knows, the two states with the throwback tax are California and New York, although a New York resident cannot set up one of these Ning Trusts. The throwback tax will tax previously untaxed income that would have been taxed in California, but for the Ning Trust. When when there is a distribution in a later year to a California resident, even if there's distributions in excess of the taxable income for that tax year, the previously un-California taxed income will be taxed at that time. That is the time that it is distributed to that beneficiary to the extent of the distribution. You can't get around that unless the client moves out of California and the distribution is then made to a non-California resident. So you can't get out of it unless you move. For our ultra wealthy clients where this is just paper money and they never need a distribution, the answer is we have avoided it successfully because they have enough income outside of the trust. For the people that are worth $5 million who just put their business into the trust that was sold for $4 million and now you're going to need to live out of it, you are just getting tax deferral if you're a resident of a state like California because of the throwback tax. So we have to analyze every situation. Great question. I don't have any magical solution other than move out of California. Let's go to the next question, Deb.
From Jeffrey Tota. If I pronounce your names wrong, please accept my apologies. Question, when split hybrid DAPT in dirty versus non-dirty, are we establishing new tax IDs for each?
Yes, I thank you, Jeff, for the question. Yes, because now we have two totally separate trusts. You can split trusts. The trustee always has the power to split a trust. So I like how you called it dirty and non-dirty instead of dirty and clean. So uh, we would get a new tax ID number for the dirty trust, and we leave the clean or non-dirty trust tax ID number alone. Now, this is more philosophical than anything because probably we don't get to this point, but yes, if we need to get to this point, and I have a great way for life insurance agents where we put the life insurance policy in, we strip out all the cash flow, for example. My friend Eric Abramson, who's on, will love this. We split the cash flow into the dirty trust, get a new tax ID number there, client can access the cash flow, but we protect the life insurance policy in the other trust. So there are awesome ways to use this. And we do get a new tax ID number because these are separate trusts now. Thank you. Let's go to the next question, Deb.
Well, the next one's from Gary Flotron. He just says, dittos on congratulations to Elena and you on the birth of Tiffany.
Oh, okay. And thank you, Gary. And Gary's one of my great friends, too. He was the one who actually nominated me for the State Planning Hall of Fame back in 2011. So I owe Gary forever for doing that for me. Thank you. Gary's one of my close friends.
Awesome. Okay, so the next two come from Jason Hochstadt. Again, if I pronounced it wrong, my sincere apologies. So I'm going to take the first of the two. So first one is, if a client owns a company that generates insurance renewals monthly from policies sold in the past, so policyholders are in various states, can the client, who's located in New Jersey, change jurisdiction of the company to Nevada to avoid the state income tax of any K-1 profits?
I'm sorry. Could you read that? I had trouble with that one. Can you read that one again? There's a lot of facts there.
Yeah, so I think what we'll do with Jason's, because he's got one right behind it that's there's multiple questions built into there. So Jason,
hey, how about this?
Jason,
yeah, please email me. I am happy to answer your question later today. I apologize. That one's a tough one for a phone call when my mind is now mush after an hour. Okay, let's go to the next one.
And he's got another one that's equally as in depth. So let's go to another one from
Sure. Sorry, Jason, but just email me. Okay, go ahead.
Harley Ruff. For the Ning Trust, won't the trust income typically be taxed at high federal tax rates since it's a non-grantor trust?
Oh, thank you, Harley. I know Harley as well.
Okay, and then she continues, I'm sorry, Steve, and she says, and where do you draw the line of recommending Nings, which will have a higher federal tax versus grantor trusts with state income tax, but perhaps have a lower federal tax?
So you're properly correct pointing out that the Ning Trust hits the highest federal bracket really quickly. In 2020, it hits that federal 37% at $12,950 of taxable income, and it hits the 3.8% net investment income tax or Obamacare tax at that same $12,950. So you don't set up a Ning Trust for a person who is in a low federal bracket because when you have to always compare their federal plus state bracket versus the Ning federal bracket. If their federal plus state is lower than the Ning bracket, then we took their money for legal fees to not help them, which we would never do. So that's why we say no to people. In fact, I had this very same fact pattern yesterday. I told someone I don't think it's going to pencil out. You almost always want to fill up their full federal bracket. Sometimes for California residents, if you can get to the second highest bracket, you can still set up the Ning Trust and make it pencil out. But you always have to compare that. We don't just set up a Ning Trust to save state income tax and cost them more federal tax. That you always compare. This is unlike a lot of the things I talked about today, like asset protection and state income tax savings. This one really needs the high net worth client. This is not the typical person that's not in the highest bracket. Thank you. Great question. And Deb, was there a follow-up to that?
No. Can we take one more?
We can take one more, sure.
One more from Thomas Hackett. Can you use a ding or ning when a client owns an S corp stock and income is sourced to other state with no income tax, but client lives in a state like Oregon with a high income tax?
Okay, great, awesome question. I love your question because we sometimes will do this. The answer is yes. So Oregon has a 9.9% state income tax. I deal with Oregon resident clients all the time and set these up. So yes, you can put the S corp stock in the trust. Since this is a non-grantor trust, you have to make an electing small business trust or ESBT election. So the trust is an eligible S corp shareholder, and then as long as the business income is not sourced to Oregon, it's sourced to a state with lower income tax, or where there's no state income tax, the out-of-state business is just like an investment portfolio or just like an out-of-state rental property. Yes, you can do this. Absolutely. And then another opportunity here you might look for is, since the client probably is not materially participating in running this business, or otherwise this would have been Oregon sourced income, arguably, you're going to want to look for someone out of state who doesn't live in a state that will cause a tax to be a trustee of the trust to save on the 3.8% Obamacare or net investment income tax too. I know I just went through something really complex for our last question of the day. Hopefully some of you who deal with this understood what I just said. So Deb, I think we're at the end because I have to make a phone call in a few minutes.
All right. Thank you so much, Steve. And on behalf of Peak Trust Company, we want to thank you again for taking time out of your very busy schedule to present this great information, very timely. And so sorry to the one person we didn't get questions answered, but you did a great job, Steve, of staying with it. His contact information is still up on the screen. If you have questions or want to chat with us at Peak Trust Company, you can reach us at info@peaktrust.com. Again, that's info@peaktrust.com. So thank you, everybody. And we will be sending a copy of the slide deck along with a recording of today's presentation. Most likely it won't get to you till tomorrow. If you don't get it, please feel free to email us. So thank you, everybody. And thank you again, Steve, and enjoy that sweet baby girl.
Thank you very much, everybody.
All right, bye.